Welcome and good afternoon, everybody. My name is Gokul Plaha, and I am a consultant with the CUTS Institute for Regulation and Competition, or CIRC. I am privileged and honored to have an academic of Professor Amelia Fletcher's eminence as our guest speaker for today's webinar, titled What Will Be the Role of Economics in the Implementation of an Ex-ante Regulatory Regime in the Digital Economy? Amongst the audience, we have distinguished competition law and policy experts, antitrust lawyers, antitrust enthusiasts, and students. I want to take a moment to personally thank each and every participant for showing up to this discussion. The CIRC strives to be at the forefront of exploring regulatory and policy issues relating to the fields of law, economics, and public policy. Let me now introduce Professor Amelia Fletcher. Professor Fletcher teaches competition policy at the University of East Anglia's Norwich Business School in the United Kingdom. She also serves as Deputy Director at Center for Competition Policy at the same university. Her distinguished career has included multiple stints with the British government. Presently, she is a non-executive director with the Competition and Markets Authority, Britain's competition regulator. The Treasury appointed her as a member of the Digital Competition Expert Panel. Established in 2018 by the Chancellor of the Exchequer, the panel was headed by Mr. Jason Furman, a renowned economist, professor at the prestigious Harvard Kennedy School of Government, and chairman of the Council of Economic Advisors to the President of the United States from 2013 to 2017. The other economists on the panel, equally eminent in their own right, were Professor Diane Coyle, Professor Philip Marsden, and Professor Derek Macaulay. The report recommended updating the regulatory regime relating to merger enforcement and antitrust enforcement in the context of the UK's digital economy. It also proposed bold pro-competition measures to quote unquote open up digital markets. Previously, Professor Fletcher served as chief economist at the Office of Fair Trading from 2001 to 2013. During her almost 13-year-long tenure, she led the merger and competition policy teams. The other distinguished positions Professor Fletcher has held with the British government include non-executive director of the Financial Conduct Authority from 2013 to 2020, non-executive director of the Payments System Regulator from 2014 to 2020, member of the Enforcement Decision Panel at the Office of Gas and Electricity Markets from 2014 to 2022. She started her career as an economic consultant with the London School of Economics, a position she held from 1993 to 1999. In her second job, which lasted from 1999 to 2001, she was a consultant with Frontier Economics, a leading microeconomics consultancy firm based in London. Professor Fletcher has held several distinguished and prominent positions, not just within the British government, but also in the academia. She has been a member of the councils of the Royal Economic Society, the prestigious professional association that publishes the world-renowned Economic Journal and the Econometrics Journal, a member of the Association of Competition Economics, ACE, a member of the Economic and Social Research Council, ESRC, Center for Economic Learning and Social Evolution, ELSE, and a member of the Berlin Center for Consumer Policies, BCCP. Professor Fletcher has also served as a member of the European Commission's Department of Competition Economic Advisory Group on competition policy. Finally, I can't not tell the audience that Professor Fletcher serves as the editor of the Journal of Competition Policy and Economics, published by Oxford University Press. Professor Fletcher's academic work is focused on competition policy, consumer protection, and sectoral regulation. Members of the audience would be happy to learn that Professor Fletcher continues to maintain a special focus on digital markets. Here's where I would want to turn the audience's attention to the law and policy context for this colloquy. Today, competition law and policy find themselves at a crossroads. Arguably, the new consensus in antitrust academia across the world is that traditional competition law enforcement doesn't adequately capture, much less remedy, the novel harms emanating from the digital economy. That's because the economics of digital markets is markedly different from the economics of traditional markets. In a report titled Anti-Competitive Practices by Big Tech Companies, the Standing Committee on Finance of India's lower house of parliament states that digital markets are characterized by, quote, massively powerful increasing return to size economies, unquote. Those increasing returns, the report goes on to state, quote, result not just from traditional scale and scope effects, but also dramatically powerful learning and network effects, unquote. As a consequence, digital markets lack the kind of fairness and contestability one can find in traditional markets. Some of the ostensibly, and I stress the word ostensibly here, novel harms flowing from these peculiar market dynamics are killer acquisitions, anti-steering provisions, algorithmic self-preferencing, anti-competitive data-related practices, search bias, etc. Not just India, but jurisdictions around the world are deliberating whether antitrust law in the digital realm needs a complete overhaul. Germany and the European Union have devised ex-ante legislations that place multiple restrictions, requirements, and obligations on the conduct of digital behemoths. And Britain has come up with a draft bill along similar lines. But these initiatives are not without opponents, many of whom claim that they would turn out to be counterproductive by deterring investment, stifling innovation, and reducing consumer welfare. Professor Fletcher will share her perspective on that debate. In doing so, she will also present her views on the economics of digital markets. Next, Professor Fletcher will talk about the challenges associated with the implementation of a regulatory initiative of the scale, size, and scope of the European Union's ex-ante legislation for digital markets, the Digital Markets Act. In particular, she will focus on the challenges developing economies like India could come to face. One critical reason behind the global regulatory trend in favor of ex-ante regulation is that ex-post competition law enforcement can be very time-consuming. It usually entails lengthy judicial proceedings, which means extensive legal argumentation, complex economic analyses, and judicial determinations with respect to relevant markets, dominant positions, and anti-competitive effects. Those inescapable requirements render ex-post enforcement unsuitable for fast-changing digital markets. After all, the argument goes, digital markets are prone to the phenomenon of tipping and consequent monopolization. That begs the question as to whether economics will continue to play a role in the enforcement of ex-ante regulatory regimes. If the answer is yes, there arises another question. What role will economics play? The main thrust of Professor Fletcher's talk will be on answering those questions. She will discuss how and why she believes economics will, and indeed should, continue to play a crucial, even if diminished, role. In particular, Professor Fletcher will discuss the crucial role behavioral economics is likely to play in the enforcement of ex-ante regulations. Finally, Professor Fletcher will discuss the implications of the divergence between the approaches adopted by the European Union's Digital Markets Act and the United Kingdom's Digital Markets Competition and Consumers Bill, especially for developing economies like India. In doing so, she will contrast the substantive features of the DMA and the DMCC Bill. Professor Fletcher will hold the floor for 20 minutes. After that, she will engage in a free-flowing discussion with the audience. Over to you, Professor Fletcher.
Thanks very much, Gokul, and thank you very much for inviting me. I should say that Gokul gave me the 4 questions that he's just been through. And to be honest, if I was going to answer each of them properly, we would be here for at least 2 hours, potentially a day, potentially a few days. So I'm going to really rush through them and actually not put that much more bones on them than actually Gokul has himself, but then hopefully open up for discussion and we can see where that discussion goes. I should also just mention, he mentioned that I am on the board of the Competition and Markets Authority. I always have to highlight that I am not speaking for the Competition and Markets Authority. I am speaking in my own right as an academic. So the first question that I was asked to think about is is ex-ante regulation for digital markets backed by sound law and policy rationale? And I think the answer is yes. And in fact, I think Gokul has already gone through some of the key reasons, and it sounds like actually the debate in India has already kind of understood this. I mean, I think, first of all, just to highlight that what I'm going to be talking about, there's all sorts of regulations being introduced in digital markets to do with privacy, to do with online harms, to do with AI. I'm going to be very focused on the very carefully targeted regulation that is tightly scoped on a small number of very large big tech platforms and is focused on competition. So one very specific aspect of all of those kind of regulatory initiatives. And as was highlighted earlier, I think there are some really special characteristics of digital platforms that in economic terms justify this. So I think basically there are very large global economies of scale, but even more than that, there are really important network effects. And they have two effects. First of all, they lead to markets tipping, as Gokul mentioned, because essentially a network effect means that a platform is more valuable to users the more other users it has. And in any situation where you have that, then everybody wants to go to the same platform because then it's as valuable as possible to everybody. But that tends to lead, obviously, to market concentration. So we see some markets where we have very strong concentration. But another thing, and I think in particular, the EU regulation has been very focused on that, is that where you have network effects, sometimes on a two-sided platform, you will have users on one side of the platform and typically consumers that only use one platform. So I only use my Apple iPhone. Lots of people only use their Android phone. And what that means is, even though there are two types of phone, and you might think that's enough for competition, actually from a developer perspective, from a business user perspective, they can only get to one set of consumers through any one platform. So they actually need to use both platforms. And that means that both platforms have got what's called bottleneck market power or gatekeeper market power over the business users that they deal with, even though they might be competing to win end consumers. And so it's quite an interesting and complex aspect of these kind of multi-sided markets, but a really important one. Then there are also really important ecosystem effects. These are a bit like network effects in one market, but they go across markets. So actually there are real benefits, economies of scale, and benefits from having multiple users, from having different services that interact with each other within an ecosystem. There are also, as part of all of that, really important data effects. So we know that data naturally comes out of these digital platforms just through their use. But that data is not only an output, it's a really critical input to the provision of these services. It is used both for training machine learning algorithms. Now, often we might be talking even about AI. So we need that data to train the AI. We also need that data to monetize. So that makes all of that makes better services. So actually that's good. There's a consumer benefit, but it also means you need the data in order to provide the better consumer services. It also really enables the monetization of those services. So if you don't have the data, you can't provide the better services and you can't monetize those services. So data becomes a really important input to enable competition. And then finally, the other economic aspect, which I'll come back to, is consumer behavioral biases, which in these markets have been found to really enable the development and preservation of market power, and also enable leverage between markets. And I'll come back to that. Obviously, we do have consumer behavioral biases in many markets, but I think for a variety of reasons, they are more, they've become more important in these digital markets. So I think what this has done is it has led to a number of, not a huge number of markets, but a number of very critical digital markets, where one or two players have highly entrenched market positions and also very strong bottleneck market power. And that, and I won't go into how, but it wouldn't be surprise you to know that that can create harm, not only for consumers, which is often the focus of competition authorities, but actually also for business users, including small business users, but also big business users. And also, even though we've seen in the past a lot of innovation in this space, actually going forward, now that we have these entrenched market positions, there is a real risk to innovation in the future. If these incumbents can't be displaced by new and innovative new propositions. So that's the kind of economic grounding. The legal grounding is really associated with whether we can rely on competition law to address some of these issues. And again, Gokul mentioned that there's an increasing feeling that competition law is just too slow. It's very hard to make cases stick. The extent to which that is true differs across jurisdictions. Some jurisdictions are actually better at making these things stick. So actually China, interestingly, is very good at it. America is very, very bad at it. Their cases are always failing. But even if you can make it stick, it takes a long time. It takes a huge amount of debate. And by the time you've usually made a case successfully, it's kind of the actual behavior was ages ago. So they're inherently very retrospective. Also, when you're trying to design remedies to solve, you can fine, obviously coming out of a competition case, but you also might want to have remedies to try and solve the market problems. Those remedies end up being, again, very retrospective, very partial, because they depend on the case that the authority happened to take, even though there was a lot of other cases out there. And also competition authorities just simply aren't really set up to do remedies very effectively. They don't see it as their key thing. So all of these, the other point to make is that some of these issues, I've talked about network effects, I've talked about data effects, I've talked about consumer behavioral biases. Those things can lead to market power being entrenched without firms actually behaving badly, in the way that competition law is really about trying to stop firms from behaving badly, strategically, anti-competitively. But actually, some of these markets competition concerns can arise in some of these markets without firms behaving badly. Actually, they have also behaved badly. We've got cases that show that. But even if they hadn't, we might have concerns here. We might still have entrenched market power. And that might still mean that we want to do something about that. And antitrust would not then be the right tool. So what we've argued is we really need a set of clear guardrails for this small number of digital platforms, which will then allow them to compete fairly and effectively with each other and with others, competitors, but which will also allow fair competition on those platforms. So, for example, between those platforms when they're acting as users of those platforms and third-party users, so that you might think business SMEs using Amazon, for example, give SMEs using Amazon, treat them fairly, give them a fair whack at competition versus Amazon's own upstream retail arm. Also allow others to compete and innovate against them in a fair way. So it's all about really leveling the playing field in a situation where it's become unlevel. So the second question I was asked to look at was, what are the challenges associated with implementing legislation like is being proposed here, these upfront guardrails, this upfront ex-ante regulation, like the European Union's Digital Markets Act and the United Kingdom's Digital Markets Competition and Consumers Bill, and especially in the context of developing countries like India. So just to highlight, and I'll come back to this later, but the UK and EU regulations are somewhat different, and the differences are interesting, but they are aiming to do broadly the same thing. They're motivated by exactly the issues I've just laid out, and they're seeking to achieve remedies to those issues that will be broadly similar. So there are two core areas of focus for these regulations. The first is interventions that are designed to try and open up some of these monopolized or duopolized markets to new competition. Okay, and that's a hard thing to do, but the sorts of interventions there that are seeking to do it are things like interoperability, because if you think about a big ecosystem, if it's closed, if it's not interoperable, then it's much harder for third parties to try and get a foothold. If interoperability is required, so third parties can at least offer their services because they're interoperable, then they can start to get a foothold, they can start to get bigger, they can start to get the data they much need and the learning they much need. So interoperability is one key aspect of that. Data access and data portability is another key element. And also, interestingly, I talked earlier about the difficulties around single homing consumers creating bottleneck market power. So there's a series of measures that are designed essentially to try and enhance multi-homing so that users can more easily use different service providers at the same time to try and overcome some of those issues. So that's one set of interventions. And then there's another set of interventions which effectively say, okay, let's take the market power as given that these platforms have. We hope that we'll do something about it. But even if we don't, what we're going to do is we're going to try and stop those strong market positions from being exploited unduly, unfairly, or being leveraged into new markets. And there we get things like prohibitions on self-preferencing, prohibitions on tying, prohibitions generally on discriminatory pricing. So in terms of a challenge, the key challenge, I think, basically relates to the fact that this sort of regulation is really new and really hard to design. No one's actually ever really done this before. There's some similarity to banking regulation. There's some similarity to telecoms regulation, but there's not that much similarity to any other regulation. So it's new, it's hard to design. Economists are scrabbling to write papers about the likely effects, but that's all, you know, there haven't historically been tons of papers. And a real risk is that if you have poor design, then not only might that not be effective, which is obviously not good, but it could also have harmful effects. And that's what we really don't want to get. And I'll give you a little example, but I mentioned self-preferencing. So the concerns about self-preferencing are, for example, think about Amazon again, huge marketplace. If in its buy box, which tends to be where everybody makes their purchases, I don't know how it works in India actually, but in the UK, there's a buy box, which tends to be the place which people tend to buy from the buy box, and the buy box essentially chooses one supplier to be the kind of default supplier. If that buy box always actually is the Amazon retail provider rather than a third party provider, so that consumers actually have to do quite a lot of work to find the third party provider, then that is arguably a form of self-preferencing that will let Amazon expand its position as a really important marketplace into being actually the dominant retailer against third-party business other retailers. So that's self-preferencing. Now, but there is also positive effects potentially of self-preferencing. There is actually an economic literature on this. If you've got a great new service and you're trying to encourage people to use it, then actually really pushing that great new service that people may never have tried before, saying, yeah, try this one, it's really excellent, that can actually be really good, but it's also self-preferencing. So it's one where it's delicate. If you get the rules wrong, you could harm the positive aspects of self-preferencing, and that wouldn't be good. And I would just highlight that because actually the US has also been looking at regulation in this space. The EU ban on self-preferencing only relates to rankings. So it says if you've got a ranking of suppliers, you shouldn't you shouldn't preference your own service in the ranking that you provide. So it's about a behavioral economics because it's about ranking and people being affected by ranking, but it doesn't ban self-preferencing completely. Okay. By contrast, the US has had 2 goes at this. Well, it's had a few goes at this. The first time it actually just banned all self-preferencing and all discrimination, which many people thought went far too far. And actually the most recent proposal goes even further. And if it went through, which I don't think it will, would ban any platform from competing with its rivals at all. For rivals using its platform. The reason that would be a bad idea, if you think about, I don't know if you have these things, but Apple iPhones and Apple also has Apple Music, and there's also a product called Spotify, which offers music. It would be very appropriate to say that Apple Music shouldn't always put Apple Music top of the list when people are searching for music programs. That would be what the EU would require. But what the US would now require is that Apple Music can't compete against Spotify at all. And there's two responses of Apple Music to that. One is to stop having Apple Music, which wouldn't necessarily be good. The other is actually to stop carrying Spotify and only having Apple Music, which would be even worse. So if this US rule went through, I think it would be basically a disaster. So that's just an example of the kind of rule that can sound good in theory, and when you think about it, it's not good. So really important to ensure that rules are effective, but also proportionate, or also don't have these very negative unintended side effects. That is obvious in a way, but it's not straightforward. And that, I think, is the big challenge. And it's also where economics is really important. So coming on to the third question, which I was asked to answer, and I realize I'm going a bit over time, but hopefully you'll bear with me, is what role will economics play in the enforcement of ex-ante regulation in digital markets? And in particular, what would be the role of behavioral economics? So I said earlier that competition law cases tend to take a long time. And part of the reason for that is that strong weight is placed in many jurisdictions anyway. I don't know actually if this is true in India, but in many jurisdictions, strong weight is placed on evidence of likely harm. And that tends to be economic evidence of likely harm. The trouble is that economics as an academic discipline is incredibly useful, but it's not actually well suited to providing evidence that is at the level of confidence that courts tend to require. They tend to require, can I be really sure that this is true? Economics doesn't usually give you that. It's kind of it gives you an estimate and kind of error bands. And so it's very useful for enabling policy judgments, and kind of more likely than not judgments is actually not that good. And actually what that tends to do is you end up with courts seeing economists arguing about what you can tell from the economics, and they end up saying, look, I don't understand, I don't know what I can do, I don't know, I can't rely on all of this, and therefore the cases don't succeed, and therefore you get under intervention. So as a result of that, the EU, in designing the Digital Markets Act, had effectively, in my view, has sought to avoid economics so far as it can. So it has taken away market definition, which is one area where economics tends to play a role. In order to designate firms, you don't have to show that they have market power, you just have to show that they meet certain quantitative thresholds. And they also have made it so you don't need to show harm. Essentially, there's just a set of rules in the legislation, and if you disobey them, you are breaching the law. There is no need to show that there's any harm associated with that breach. So it takes the economics out. So this has led to a debate about, well, does it take it completely out? Or is there some areas where economics will still play a role? And I have a paper which people can go and read if they want, is with other authors, which talks about, first of all, what I've just described, why economics has been taken out, and actually kind of says it should have been. I mean, it's not a silly thing that it's been taken out, but then talks about, nonetheless, the role it can usefully play. And so, for example, one role it could usefully play is in terms of self-preferencing in ranking. So I talked earlier about Amazon putting its own service in the buy box. That's a form of ranking. It's self-preferencing in ranking. But sometimes that will be right. If Amazon has the best product, it's perfectly good to put it in the buy box. That's not self-preferencing. That's just giving an organic, fair result. But how can you distinguish self-preferencing from giving yourself the best ranking, but on objective grounds? And I think economics is going to be quite useful for distinguishing between those two situations. And in our paper, we have a whole set of other areas where we think just economics is going to be needed, even though the things look very clear legalistically in the legislation. When you think about them harder, they are going to need economics. One area where we think that we're definitely going to need more economics is around behavioral economics. And interestingly, I think the Digital Markets Act is possibly the most well-informed legislation that I've ever seen from a behavioral economics perspective. It absolutely recognizes that platforms can steer end user behavior through the use of defaults, through rankings, through complexity, and that steering can have positive effects, but can also have anti-competitive effects. And it tries to draw the line between the positive and the anti-competitive, I think, pretty neatly. It does it through specific rules, for example, around default settings, but also through a more general requirement around effectiveness. So when the firms are trying to show that they are compliant, they have to do so not only saying that they're abiding by the rules as set out in the legislation, but that they are abiding by those rules in a way that is effective in promoting contestability and fairness, which are the objectives of the regulation. So I think that's it's very neat because it stops firms from just kind of doing the minimum and really requires them to think about, actually, what is the impact of what we're doing on consumers, and is it really enabling them to make the decisions that they should be making, or are we steering them unduly? And then the fourth question I will talk about is what are the implications of the divergence between the regulatory designs of the Digital Markets Act in the EU and the UK Digital Markets Competition and Consumers Bill? And in what ways must this divergence inform regulatory design in developing economies like India? And I talked about the challenges with competition, the challenges that I thought this regulation would involve earlier. And I talked about it's just very hard to design. But a second big challenge actually relates to enforcement. How do you enforce this kind of law without just having millions of staff in your agency? And in that context, I highlight that the EU claims that they think they're going to be able to do this with a staff of 60, which I actually don't believe, but that is what they claim they're going to be able to do. This is immediately where you see a difference between the UK and the EU. So the EU's approach, and why they think they can do it with a staff of 60, is to have very clear rules in legislation, and then to place responsibility on the designated platforms to show that they are complying. So they have to every year produce a compliance report that sets out in detail why they consider that they are complying with the DMA. And enforcement then becomes much, much easier, because essentially you don't need to show actual harm. You don't even necessarily need to show non-compliance. You can basically bring cases against them if they fail to show compliance. So that should be a lot easier to enforce. Now compare that with the UK. The UK was concerned that having the legislation, the rules in legislation, and having them so, you know, so unflexible, could actually have some unintended harmful side effects. So the UK system is designed to be more evidence-based, more bespoke, more proportionate. So what the legislation is going to do is give a set of criteria, but it's not actually going to set out the rules. That will be left to the regulators. The regulator is going to look at the actual evidence of harm and develop a set of rules. We have yet to see how different those rules will be to the DMA rules. They will hopefully not actually be that different, but the process is very different. What that does is it really moves forward in trying to be more measured and avoid unintended side effects, but it is more difficult. It will require more staff. It definitely involve more economics, and there is a real risk of being tied up in legal knots. So it will be really interesting to see actually how this goes. The EU is arguably going to be easier, but could have unintended side effects. The UK is arguably going to be better if it is actually practicable, but we will have to see. I'm hopeful it will be, but there's actually debates going on in Parliament at the moment about whether we can retain, whether that changes need to be made that, in my view, would in fact make it less practicable. My personal view is that unless India wants to throw a lot of people at this, however, they would probably be better off with the DMA style approach. In doing that, obviously, it would be important to look at all of the specific rules and consider how relevant they were to the Indian situation, and I have not done that at all. But I would suggest that it would be better to take rules away rather than adding any new ones. And the reason is I have a personal fear that people around jurisdictions around the world are going to look at the EU DMA and say, oh, that looks good. Okay, we'll have that. But actually, we've got some specific issues in our jurisdiction. So we'll just add this extra rule, and somewhere else adds another extra rule, and somewhere else adds another extra rule. These are global companies. They're trying to compete on a global framework. More importantly, actually, their rivals, the rivals that we want to try and compete against them, are also competing on a global framework. Yeah. So the more that we can have more or less global rules, recognizing that it's going to be impossible to get them completely consistent, but the more we get more or less global rules, the better, not only for the firms themselves, but also for their potential competitors, also for the business users that use them. It will just be much clearer and easier to form a business model if you know what you're dealing with on a global basis. And if everywhere adds little tweaks, I think there is a real risk of creating a kind of regulatory edifice that overall does do more harm than good. So I will finish there. I took 30 minutes rather than 20 minutes, but for which I apologize, but I'm very interested to hear the discussion.
Thank you, Professor Fletcher, for what was an excellent talk. I'm sure the audience has learned unique insights. they would probably not be able to learn anywhere else. We will now allow questions from the audience. Please, you can raise your hand or you can type your question in the chat box. Alternatively, I encourage you to come on camera and ask your question directly of Professor Fletcher.
I can see that Navneet has already put a question in the chat. I don't know if you want to say the question.
Right.
So I'm asking that you mentioned, Professor Fletcher, about the rationale, economic and legal rationale behind EU's DMA. And you also explained about the British logic behind settling for a different set of approach. One of the problems you mentioned initially was that the protected litigation rendered the post facto remedies ineffective.
Yeah.
Right. But a conceptual question is that in any rule of the law jurisdiction where you have a constitution and the provision of judicial review, even the DMA kind of approach will be subject to judicial review. So how do you see that the protected litigation problem is going to be solved? So and I think if you allow me 20 more seconds.
Of course, sorry.
What I mean to say is that, and when I ask this, I am also asking an attendant question, that why the settlement and commitment regime of the DGCOM, why that could not elicit the desired outcomes that the DMA was necessitated. I mean, I see DMA's birth as a failure of settlement and commitment. That's the way I read the two together. Over to you.
Okay, they're two slightly different questions. So I think that the first is about whether the EU will be immune to this sort of litigation that I'm worried about seeing in the UK. And I think obviously it will not be immune. I think we're already seeing the companies gearing up to litigating. There's another law that's just gone through in the EU called the Digital Services Act, which is about online harms. And in fact, that has already been appealed, well, the application of particular elements of it to Amazon in this particular case has already been appealed, and that appeal is going through at the moment. Actually, in that particular case, I happen to have some sympathy for Amazon's argument. So I think that in the DMA, I think we will know in the next month or so whether the firms are going to judicially review the rules as applying to them. And some of them may well try and judicially review some of the rules as applying to them. It will be really interesting to see how that pans out, because those rules were effectively imposed by the Parliament rather than by the Commission, which is the regulator. So they will have to somehow show that the parliamentary intention was not to do what these rules are actually doing to them. So we will see. But I don't think it's an easy judicial review at this stage. I think the later stages will be when the Commission tries to sue for non-compliance, and the firms will say, well, I am complying to the best of my ability. This rule is just poorly designed, and if I complied any more than this, it would actually have negative effects. And that will be, we'll see those sorts of those arguments made as well. I think all of that is true, and I'm sure we'll see it. There's huge amounts of money at stake, and those firms are very well financed, and so they will bring those cases. But I do think that those cases will be a lot harder, and therefore they will think twice relative to a system arguably in the UK, where the regulator is trying to get every single rule even to stick as being effectively evidenced. So, I mean, I'm really, really hopeful that actually, if I was the firms, what I might want to do is be relatively do less litigation in the UK, because the regulator is trying to be proportionate and measured. And I would want to say, look, actually, the UK is doing it right. And therefore, we're not going to mess it up by lots and lots of entangled litigation. We're actually going to say the UK is doing it right. And all you guys' arguments for why the EU was better is wrong. Because look, we're suing in the EU and not in the UK. That would be brilliant and very clever by them. But I don't, well, we'll see. We'll see. Your second question was about settlement and commitments failure. I mean, I do agree that to some extent, I think we have not been seen enough settlement and commitments. Obviously, settlement and commitment does require the voluntary agreement of the firms concerned to finish a case basically before the end. There have been cases where there have been attempts at settlement and commitment that were unsuccessful in the EU, and where in the end they've gone to the end, where essentially their feeling by the Commission was that the parties were not offering good enough remedies. But I think actually if you think about most of what I said earlier, I don't think that would be solved by more effective settlement and commitments. It would be solved a bit, but it wouldn't be solved completely, because you still wouldn't have this, you still wouldn't be able to get through lots of cases, you still wouldn't be able to have these overarching rules, and you still wouldn't be able to introduce the kind of rules that you might want even if firms haven't behaved badly, like interoperability rules. That requiring interoperability doesn't necessarily mean firms have behaved badly. It just means that actually we think there'd be more competition with interoperability. So I think those sorts of rules might well be very hard to get out of a competition case. That said, and this is where I think there is something useful to say in regards to India and other developing market jurisdictions. What you now have in terms of settlement and commitment in competition law is you have a situation where firms are required to do something in the EU. And if they are required to do something in the EU, the costs and benefits of doing it in India will inherently have changed. They will have had to design their systems again, and therefore the costs and benefits of doing something in India will be different. So if now India wants to take competition law cases to try and achieve some of the benefits that the EU is getting through the Digital Markets Act, I think India is in a much better position to do those sorts of cases and get settlement and commitments because of that change in cost and benefits than it was before the DMA. So I don't think it would be a silly idea necessarily for India to see how much of the DMA it can get just through competition cases and commitment and settlement without doing the actual regulation. But that's only because someone has regulated. So I think there's a question.
Yes, is there? I'll just encourage everybody, whoever wants to ask a question, please put it in the chat box so that all of us can see your question. Alternatively, please come on camera and ask. Please feel free to come on camera, or you can directly message me your questions directly. Is the third option. Do we have other questions? We have
limited time, and if there are no questions, I want to ask one more question. Is there a question, Gokul?
Well, there is a question in the chat. There's a question in the chat, but it was directed only directly to me. It's from Mrinalini Shrivastava, but I'm not sure I fully understand it. So I think they would need to explain it a bit more to me if they want me to answer it.
Sure. Miss Mrinalini Shrivastava, can I please request you to ask your question on camera, or you can just kind of
up to you.
Yeah, just message me your question in the chat box.
In the meantime, let me let me pose a follow-up question. And I can see in the list of participants, friends from different jurisdictions from Africa. I can see friends from Namibia, South Africa, Kenya, Australia. I can see a good number of jurisdictions in this room right now. And Professor Fletcher, let's, and this is, consider this as an academic question from my side. So these economies are at different levels. EU is at a different level, and each economy has got its own economic heft, plus the level of development, the level of digital penetration. So EU is at a different level. India and Namibia, South Africa, Kenya, and Ethiopia. Everybody is at a different level. Now, let's say, for the sake of academic clarity, let's put them in 3 different layers. A, very minimal digital penetration. B, somewhat medium penetration, and high level of penetration. Now, how can the 3 sets of economies really figure out their digital regulation?
So I think you're absolutely right. That's a really good question. And I think that, first of all, if you've got relatively low digital penetration, then actually you might not have a particularly big competition issue at the moment, because actually I think what has motivated a lot of the concern in the EU and the UK and the US is that there is such heavy digital penetration that digital really sets the competitive framework for non-digital as well. So actually it becomes a situation where if digital is not working very well, the entire economy is not working very well. I think if you don't have that situation, so if you've got low penetration or possibly even medium penetration, I would think that the argument for regulation would be massively reduced. That said, there is an argument that some rules up front would be useful. I'm not saying the full panoply of rules, because actually what happens in these markets is they grow and then they tip and then they become entrenched, and actually acting earlier can be very, very helpful. So but the earlier you act, the more worried you have to be about unintended side effects, because you could hamper innovation, you could hamper firms from even developing in your country. So it is a really tricky thing to do, but I don't think it's I don't think it should be completely ruled out. But I agree that the pressure is lower for the sorts of regulation I've talked about in those countries, and maybe those countries would do better to pick off particular issues using competition law and settlements and commitments, as you suggested. I think the other thing in smaller countries, which is less about the digital penetration, well, it's a bit about digital penetration, and more just literally about their size or the money that is involved, is that there is a real risk with this regulation, and it shouldn't be understated, that platforms will just either take a service out of a country, a jurisdiction, leave the jurisdiction completely, or fail to, or just offer a less good or different in some way version of the service in a jurisdiction, not invest in it, for example. And I think that is a real risk as well. Even the EU, I didn't mention this, but in the Digital Markets Act, if the party, there's not many caveats that can be put in place to get you out of having to abide by a rule, but there is one important one, which is if well, I mean, there is a few, but there is a particular, an important one in this context, which is that if a platform can make the case that they would have to pull a service out of the EU completely, it would become non-viable if they were to abide by the rule, then they can say we shouldn't have to abide by the rule. So you can include that in your regulation, but I think actually more generally, it's a thing to think about. If you are a jurisdiction and you're thinking about introducing these sorts of laws, what is the implication going to be for the incentives of these firms to build up and offer their services in your country? And is there a real risk that people pull out, And I genuinely do think, and I'm sorry about this in a way, but I genuinely think that is a risk for smaller jurisdictions, which may be a reason for jurisdictions to work together. So, for example, if I don't know how this could realistically be done, but if all of if a large set of African, this probably isn't an issue for India, because I think India is so big that India does have the heft. For those smaller African countries, if they could get together and say they're going to do something jointly, then again, that means that the firms are less likely to pull out because they don't want to pull out of all of those jurisdictions. So I think that joint cooperation, coordinated action would help, but I recognize the issue.
Thank you. And
right, we have a question.
Since Gokul introduced you at the outset, I've been wondering whether you are a superior teacher or a superior policy advisor. And I must admit that you're superior at both. Gokul, over to you.
Yes. So I'll just ask a question that Ms. Mrinalini Srivastava has asked. Her question is, what opportunities exist for developing global public goods for dispute resolution and regulating the digital economy, and how can international collaboration and harmonization be leveraged to harness the potential of that?
Okay, when I said I didn't fully understand it, I don't quite know what global public goods for dispute resolution is, but what I would say is, in an ideal world, we would have global regulation of these firms, and we would have global dispute resolution, and that, because actually, as I said, they compete on a global basis, so it's fairer to them, but also their competitors and their business users act on, to a large extent, many of them act on a global basis, and therefore it would be more appropriate for them as well. I mean, I think it is a negative for the UK that we are now not part of the EU, because we would be in a bigger global bloc we could have a bigger block of dispute resolution. I just, however, feel that it's unlikely that we're going to get anything globally in the short term, at least. But I don't think that inhibits blocks of countries coming together and trying to do some of this in a coordinated and collegiate way. So I would, I mean, I'm really not a trade expert, but I would encourage as much of that to be done as possible.